We're here at the bar office on September 29th, Thursday, September 29th. And I'm going to introduce this fellow to my left, Dan McKay. The process that we've gone through is this. We realized that there's going to be legislation introduced this year on capping recoveries on commercial motor vehicle collisions accidents. There's been legislation that's been at the Capitol for the past 2 years. We've managed to avoid having that pass. We know we're going to be in for a big fight this year. As a result of that, we recommended to the bar officers and the administrative committee that we retain a consultant to research the subject and to provide information that is put together so that we can present it to the legislature, and if necessary, have the consultant testify at subcommittee meetings or whatever. We plan on having Dan present to the Board of Governors meeting. And so with that, I just want to tell you just briefly a little bit about his background. Dan is from Knoxville, Iowa, and it was in the insurance business, the insurance work for 41 years, had his own agency down there. He's very familiar with all lines of insurance. He's sold insurance for commercial motor vehicles. He's familiar with how the insurance commissioner makes rates on policies, and he's done quite a bit of research on the subject. So with that, we're going to turn it over to Dan, who's now doing consulting work, and that includes working for the Iowa State Bar Association. Thank you.
Thank you, Jim. Well, hello, my name is Dan McKay, as Jim said. I'm a consultant for the Iowa State Bar Association in regard to examining questions about capping insurance settlement recoveries on commercial motor vehicle accidents. As you undoubtedly know, the Iowa State Bar Association has and is opposed to recoveries on commercial motor vehicles, and in my opinion, for a good reason. Let me tell you a little bit about myself. I owned an insurance agency in Knoxville for over 41 years. I sold all lines of insurance, including insurance for commercial motor vehicles and other lines of business. I have sold my agency, but I'm now engaged in consulting on an insurance consultant basis on all insurance-related issues. Insurance has been my life's work, and I'm knowledgeable regarding how insurance rates are set and what affects rates, including commercial vehicle rates. I reviewed the legislation which was proposed last year, capping recoveries on non-economic damages at $1 million per occurrence. The word occurrence limits the recovery amount to all damaged parties. In my opinion, after careful research, there are 5 reasons for Iowans to pose caps. Here they are. Number 1, insurance rates would not be materially affected by a cap on damages. We have one of the lowest costs of insurance in the country. We're number 3 currently. In my conversations with the clerk of court, they could find no case where damages for non-economic loss were ever over $1 million limit. A more effective way to lower rates is to reduce the frequency of losses. Pass a distracted driver law, higher penalties for violations, give law enforcement the tools to enforce the law, provide better training for drivers, higher standards for licensing, including stronger background checks and physicals that detect sleep disorders and physical conditions that may limit a driver's ability to perform his duties. Losses may be higher as the cap becomes the ask. States that have enacted caps and thresholds have seen increases in premiums due to the cap becoming the ask. More claims could be litigated to reach the cap, causing higher claims costs. Number 3, the fairness of caps and claims settlements. Stay-at-home spouses, retirees, others who are not engaged in the workforce, and low-wage earners are unfairly discriminated against in limiting the amount of damages that can be assessed for non-economic loss. No ability to adjust for inflation, and it penalizes Iowa citizens who are injured by commercial motor vehicles coming from all over the country traveling through Iowa who do not have such legislation in their home state. Number 4, increased litigation, challenges to the cap, cost of overturning a law that may not be constitutional. States have overturned cap laws in the past. Number 5, cap laws take the decision on damages from the courts and juries and places it with legislation. Iowans must preserve their rights to a jury trial to determine the damages. Legislation does not consider the magnitude or the number of injured in an accident. In discussing this issue with your legislators, you should emphasize all of the above discussion, but also note that as far as rate making is concerned, reducing the frequency of accidents is in the best interest of the commercial motor vehicle owner's insurance premium and for the safety of the public. Reducing the frequency of losses should be priority number 1. I thank you for the opportunity to consult with the Iowa State Bar Association on this very important subject. I welcome any questions from lawyers across the state on this subject. You may contact me by emailing me at dtmckay1047@gmail.com. That's dtmckay1047@gmail.com. Or contacting Dwight Dinkla at the Iowa Bar Association headquarters or your lobbying team of Jim Carney, Doug Stripe, and Jenny Norman. Thank you.